Equal protection under the law. Hey, we often hear about that here in the United States, and in fact, everyone is given equal protection under the law. Equal protection under the law, does that apply to jury cases? Well, that discussion takes us to this week's case. When a jury is selected, one thing you need to be aware of is that the attorneys representing both the plaintiff and the defendant each have what are called preemptory challenges. Preemptory challenges allow either the plaintiff or the defendant to excuse people from jury service. They don't have to state any reason. They just simply say, hey, we don't care to have Ms. Smith, Mr. Jones serving on the jury. Don't have to state any reason. Number of preemptory challenges vary from state to state. They also exist at the federal level. Generally, preemptory challenges number about 6 on each side. All right, well, it takes us to this week's case. And in this week's case, it was a pharmaceutical case. It involved an HIV medication. Well, needless to say, the parties were concerned as to whether or not people who were homosexual, people who were gay or lesbian, would be allowed to serve on the jury because it dealt with this HIV medication, and people in that set of the community have a particular interest in seeing that such medication is developed and made available. All right, well, the jury process went forward and the selection of the jury was taking place. Found out that one of the sides was using their preemptory challenges consistently, or so it appeared, to exclude anybody who was either gay or lesbian or appeared to have such characteristics when they possibly referred to their partner. All right, well, the case was concluded. Folks on the other side weren't excited about what happened, and they appealed the case to the Ninth Circuit. And at the Ninth Circuit, federal Ninth Circuit, which covers a lot of real estate in the western part of the United States, the court looked at it and said, hey, we look at the transcript here and we find that indeed one party was pretty exclusively beginning to exclude people who did appear to have a sexual orientation that indicated they were homosexual. And because they consistently were doing that, they excluded from the jury pool individuals who frankly had a right to serve in order to show basically what the community values were, which is the purpose of a jury. By excluding them, they were essentially demonstrating a prejudice, a bias towards them. And that can't take place under the equal protection that we have here in the United States. Now, granted, this was a civil trial. Now, interestingly enough, a similar case arose in the Eighth Circuit, and there the court reached a different decision, indicating that this controversy as to systematically excluding people who based upon sexual orientation may be heading up to the Supreme Court. But what's the point of this case? Why am I talking to you about this today? Well, the point of this case is that we are seeing expansion of what are viewed as the civil rights of people if their sexual orientation is other than heterosexual. In short, that people who are gays and lesbians are increasingly having their civil rights recognized, and in recognition of those civil rights, they are being accorded the opportunities that are available to everybody, particularly to the heterosexual population, all of the time, such as the right to serve on a jury. So the point of that being, on a case-by-case basis, we are seeing the civil rights of people who are gay and lesbian increasingly being expanded. And the point of all of that is that it shows the way in which the law is a living organism. It's something that changes based upon value, based upon we as a people viewing particular social issues. And in this instance, we're increasingly, as I say, are seeing civil rights extended to people irrespective as to their sexual orientation. All right, we bring you this case as we bring cases every week so you understand how the law works. I'm David Allen.